Hello folks, investigative blogger Crystal Cox here, and this is part 2 of my filing to the Supreme Court on a motion to rehear where the Ninth Circuit judges accused me pretty much of extortion. And I had showed you in part 1 of where the case had been docketed to the Supreme Court, and I'm going to probably repeat a few of these questions here, but it starts out, with the questions that you want the Supreme Court to answer. So I'm going to start, and like I said, probably repeat some that I already said, but we're just going to start with the continuation. Okay, do judges have a right to deny due process in lower courts by issuing a ruling that convicts litigants of crimes, thereby prejudicing them with a jury of their peers as they return to have a new trial? Do judges involved in a slanderous, possibly defamatory statement, possibly criminally defamatory statement, have a legal and constitutional right to rule on whether they rehear this issue of them acting inappropriately and unlawful in that very ruling? Is it lawful and within the constitutional rights of a defendant, such as petitioner, for a panel of judges to use a New York Times article to convict a litigant in a civil trial of a crime of which they have not been adjudicated for? Okay. Then after this section is parties. And then after parties is, we just go over the opinions that led up to this, that what gives the Supreme Court the right to hear this. And so then I list all of those opinions, and then I list the table of contents, and you have to put the pages, where everything is, and then the appendix, which is all of those listings that you just talked about, all those opinions, like the denial of the motion to rehear, the January 17th ruling where I won, but yet they called me a criminal, and then the lower court ruling where the judge said the First Amendment didn't apply to me, and then the motion to rehear, and then the fact that was denied. Okay, and then you give case law and criminal procedures. Let's see, I give due process laws, constitutional and statutory provisions involved, and then now we're at the section of why this petition should be heard. Okay? Okay. To establish firm guidelines for all district court judges and appellate courts that it is not constitutional, ethical, nor lawful to render rulings that accuse litigants of criminal activity of which they have not had due process of law in regard to. To guarantee the rights, liberty, equality, freedom, due process rights, and free speech rights under the U.S. Constitution for all citizens, pro se litigants, anti-corruption bloggers, citizen journalists, and whistleblowers alike. To guarantee the First and 14th Amendment rights of all. To guarantee the rights of due process and the Bill of Rights to all. To end extreme prejudice by local, state, and federal judges whom use their power and position to silence, intimidate, and suppress speech, bully, paint in false light, slander, and defame litigants who expose corruption in the judicial system and of whom they have had extreme prejudice in regard. Okay, and the next section is called Statement of the Case. This case involves wrongful, non-adjudicated allegations of criminal conduct made by Ninth Circuit judges Arthur L. Alarcon, Milan D. Smith, Jr., and Andrew D. Horowitz against petitioner, defendant Cox, and clearly violating her constitutional rights, human rights, and rights to due process as a matter of law. Okay, then I put their statement again. Okay, that they'd said that Cox has a history of making similar allegations and seeking payoff in exchange for retraction, which thereby leads the public at large, media, and the lower court in her pending $10 million civil case to believe that Cox has been under investigation by authorities and found guilty of the crime of extortion or blackmail, as it is illegal to make allegations and seek a payoff to retract those allegations. Cox praised this court orders the Ninth Circuit to redact the above statement. Petitioner Cox alleges that it is not fair, ethical, equitable in rights, constitutional, nor appropriate as a matter of law and rules of procedure for Ninth Circuit judges or district court judges to state unrelated allegations, rumor, and speculation in an esteemed higher court ruling, that it is published to the world and affects the life of petitioner forever, as well as affects all whistleblowers, citizen journalists, and anti-corruption bloggers like her. Petitioner Cox alleges that it is an abuse of power and process and an extreme violation of human and civil rights for judges to use hearsay and rumors as adjudicated fact in an esteemed higher court process and to seek revenge, retaliate, and use extreme prejudice against petitioner and litigants like her by using a prestigious court ruling to paint petitioner in false light, slander and defame petitioner, and cause her a lifetime of irreparable harm. Petitioner alleges that it is the duty of the Ninth Circuit judges to report anyone they deem a danger to the public. If Arthur L. Alicarn, Milan Smith, and Judge Andrew D. Hurwitz believe Cox to have a history of extortion or blackmailing conduct, then it is their duty as public servants to order a criminal investigation by the proper authorities, and it is not their duty nor legal right to simply flat out state that Cox has a history of these criminal actions and thereby defame and slander Cox and put her under extreme prejudice as she heads back to the lower court pro se to face a $10 million civil court proceeding. Petitioner and bloggers, whistleblowers, citizen journalists like her face extreme prejudice in the courts as they are oftentimes exposing judges, attorneys, and people in powerful positions such as CEOs and politicians. This court ruling essentially gives the right to all judges at every level of our court system and essentially all institutional press, traditional journalists, to simply accuse litigants of crimes, activities, or unethical behavior based on gossip and hearsay of an institutional press journalist such as Kashmir Hill of Forbes or David Carr of the New York Times, and have that be stated in a Ninth Circuit ruling as adjudicated fact. Petitioner alleges that it violates her constitutional rights and the rights of those who engage in the same online activity as her for judges to essentially take potshots, add in gossip and hearsay into a ruling and thereby slander, defame, and ruin the life of the litigant. Especially in cases such as the petitioner, where she faces a retrial in a $10 million civil case where she is indigent and cannot afford an attorney and has criminal accusations prejudicing her in her lower court ruling before the trial even begins. Petitioner alleges that allowing Ninth Circuit judges to state arbitrary allegations and accusations in authoritative higher court opinions will potentially chill the online speech of all bloggers, whistleblowers, citizen journalists, as they will fear the same thing happening to them. This is a critical First Amendment issue and a critical issue of due process laws, the 14th Amendment, civil rights, and human rights. Petitioner alleges that she has a constitutional right to due process in the criminal justice system and that it violates her constitutional rights for a higher court esteemed judges to rule on matters of her alleged criminal activity before she has been adjudicated or under investigation by the proper courts and legal procedure in the criminal justice system. These accusations by Ninth Circuit judges prejudice the litigants such as petitioner in the retrial at the district court level and put them under extreme prejudice in all matters of their life, even things as simple as renting a home or getting a job. Those researching litigants, such as petitioner, find a higher court ruling issued by esteemed judges in a powerful position of which the public at large deems to be of the utmost authority, in which accuses the litigant of criminal activities of extortionate behavior. This is a violation of petitioner's rights, of due process and constitutional rights, as she now faces extreme prejudice, hate, inequality, and duress in all aspects of her life. She is deemed a criminal when she has not had due process in the criminal justice system. This precedence now makes it so that judges everywhere can do the same thing to essentially punish, retaliate against whistleblowers, citizen journalists, and anti-corruption bloggers. Does petitioner, defendant, litigants in a civil case have a human constitutional right and right under U.S. Code to be considered innocent until proven guilty? Petitioner alleges that she has a constitutional right for it to be proven as a matter of law beyond a reasonable doubt that she is guilty of a crime before judges are allowed by law to state those allegations in a court ruling, a court opinion. Beyond a reasonable doubt is the highest standard of proof that must be met in any trial. In a civil litigation, the standard of proof is either proof by a preponderance of the evidence or proof by clear and convincing evidence. There was neither in the Ninth Circuit appeal of Obsidian versus Cox. Petitioner Cox alleges that judges must have a clear and convincing proof beyond a reasonable doubt before they are, by law, allowed to state such allegations in a higher court ruling. Cox was not on trial for crimes or civil matters involving allegations, investigations, or even a cause of action regarding posting content or allegations of others online and then seeking a payoff to remove those allegations, otherwise known as extortion or blackmail. Cox was on trial for defamation, and that this was the only cause of action. There was no seeking a payoff to remove allegation as a material factor of Obsidian versus Cox, nor a factor in this case whatsoever. Therefore, it was not a matter of record and cannot legally be brought into the Ninth Circuit proceeding, and certainly not as a matter of law and constitutional rights be stated in a Ninth Circuit Court of Appeals ruling opinion. Petitioner Cox alleges that due process of law, 14th Amendment, and her rights under the Bill of Rights have been violated by judges accusing her of criminal activity in rulings, opinions in civil cases of which these crimes have nothing to do with. Cox alleges this is a retaliation for her exposing corruption that involves judges and people with financial and political power. Petitioner Cox alleges that she has a fundamental constitutional guarantee that all legal proceedings will be fair and that one will be given notice of the proceeding and an opportunity to be heard before the government acts to take away one's life, liberty, or property. Yet Cox has not been given notice of the crimes alleged, nor a way to present her side. Cox was not given due process as a matter of law and constitutional rights, and Cox has thus lost her life as she knew it, her liberty, and has lost personal property in this matter. The Due Process Clause of the Fifth Amendment asserts that no person shall be deprived of life, liberty, or property without due process of law. This amendment restricts the powers of the federal government and applies only to the actions by it. Petitioner Cox was not given due process and was simply ruled guilty of criminal activities with a New York Times article as material evidence in the matter and was thereby deprived of of life, liberty, or property without due process of law. The Due Process Clause of the 14th Amendment declares, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Yet Petitioner Cox was not given due process in the criminal justice system, nor has Cox been adjudicated for or even under investigation for the crimes of extortion. Yet high court judges accused Cox of extortionate behavior in a ruling of a civil case, a defamation case, unrelated in its material fact, evidence, and testimony to the crime of extortion and to having a history of making similar allegations and seeking payoff in exchange for retraction, which is essentially the felony crime of blackmail or extortion. The Due Process Clause of the 14th Amendment has also been interpreted by the U.S. Supreme Court in the 20th century to incorporate protections of the Bill of Rights, so that these protections apply to the states as well as the federal governments. Thus, the Due Process Clause serves as the means whereby the Bill of Rights has become binding on state governments as well as on federal governments. The Due Process Clause of the 14th Amendment is intended to protect individuals such as petitioner from arbitrary actions by state as well as federal governments, which include the arbitrary actions of an esteemed higher court judicial panel in accusing petitioner and future litigants like her of criminal activity of which was not a material factor in her case and was simply hearsay by a traditional journalist of the institutional press, in this case a New York Times journalist, David Carr. Due process requires that the procedure by which laws are applied must be even-handed, and in this case there was severe prejudice and inequality, and Cox has thereby suffered harm, and wishes this court to remedy this ruling to protect the future of all anti-corruption bloggers, citizen journalists, and whistleblowers such as herself. Petitioner Cox alleges that under 42 U.S.C.A. 1983 and other human rights and civil rights laws and constitutional amendments that the actions of these judges deprived her of fundamental fairness and of civil rights under the Due Process Clause, and now has the potential to do so to all future anti-corruption bloggers, citizen journalists, and whistleblowers such as herself. And with this gives far-reaching unconstitutional powers to the institutional press and traditional journalists to publish gossip, hearsay, and allegations, and have Ninth Circuit judges and judges across the land use these traditional journalists' opinions, writings, allegations as adjudicated fact, hard and fast evidence, and sworn testimony that gives them the right to issue opinions and rulings that flat out accuse litigants, such as petitioner, of criminal activity in which they have not had due process of law in regard to. The Bill of Rights contains provisions that are central to procedural due process. These protections give a person a number of rights and freedoms, including the right to be told of the crime being charged, the right to cross-examine witnesses, the right to be represented by an attorney, freedom from cruel and unusual punishment, and the right to demand that the state prove any charges beyond a reasonable doubt. Petitioner Cox was deprived of these rights, as judges simply portrayed to the world she was guilty of criminal acts without having due process and without being told of the crimes being charged, the right to cross-examine witnesses, the right to be represented by an attorney, freedom from cruel and unusual punishment, and the right to demand that the state prove any charges beyond a reasonable doubt. The decision of the Ninth Circuit to allow statements of non-adjudicated criminal accusations to be put into a ruling in a civil case, whereby the litigant has not had due process for those allegations, is clearly incorrect. Ninth Circuit judges Arthur L. Alarcon, Milan D. Smith Jr., and Andrew D. Horowitz erred in stating that Cox had a history of these criminal activities and erred in stating the New York Times as their evidence of fact and material facts of law. Petitioner Cox alleges that Ninth Circuit judges do not have a lawful constitutional right to issue an opinion on criminal allegations in a civil case in which the criminal allegation is not a matter of record in the lower court, has not been adjudicated, and is not a material factor in the case. Petitioner Cox alleges that she was denied a legal right to due process of law in this ruling that slandered and defamed her and painted her in false light, thereby affecting the rest of her life. Petitioner Cox alleges that Ninth Circuit judges Arthur, well, you know their name, did not find Cox guilty of these allegations beyond a reasonable doubt, nor did they adjudicate Cox, charge Cox with these allegations, nor use adjudicated fact in issuing their judicial authority opinion ruling, and that it was an error to rule that Cox had a history of such criminal action when Cox was not allowed due process and constitutional rights regarding these allegations. Petitioner Cox alleges that Ninth Circuit judges violated her 14th Amendment rights, Bill of Rights, and due process of law rights by alleging Cox committed these criminal actions of which she had not been charged by a lower court nor the criminal justice system as a matter of law. Petitioner Cox alleges that Ninth Circuit judges prejudiced her substantial rights, and this was not a harmless error, as Cox now faces extreme hate, prejudice, slander, and defamation, and has other judicial proceedings that are now prejudiced against her. If Ninth Circuit judges believed Cox to have committed these crimes, these criminal acts, they should go through due process of law. Judges are not above the law. Then talks about jurisdiction, and then the conclusion. The conclusion, I wrote, I pray that this esteemed panel, this court, send a clear message to the Ninth Circuit and essentially all appellate judges and all judges across our court system that it is not okay, not ethical, not constitutional, nor lawful to ad lib, make criminal allegations, introduce new case information into the appeal process, slander and defame litigants, and abuse the power of their process and esteemed role to retaliate against whistleblowers, citizen journalists, and anti-corruption bloggers in every town in the United States and essentially the world. The Obsidian versus Cox Ninth Circuit ruling is known well worldwide, and it is the most prominent case to date of a blogger making a court rule on whether a blogger has rights equal to a journalist when it comes to the First Amendment, shield laws, retraction laws, and free speech rights. This is a massive human rights and civil rights issue, as now all who expose corruption and break news, report on what is really happening in small towns, big cities, and essentially everywhere, have the same right in the courtroom as does traditional journalists and the institutional press, otherwise known as big media. Therefore, it is imperative that this ruling not be tainted with giving those same traditional journalists of the institutional press superpowers to have that same blogger alienated, outcast, painted in false light, prejudiced in other court proceedings, and have the world at large believe them to be criminal and therefore not take serious that in which they are exposing or reporting on. This ruling that gave equality seemed to have took it away in the very same ruling. Petitioner Cox has never, not even once in her life, posted anything online with the intention of seeking a payment for retraction. Never. Cox has never asked for money to remove anything she has posted online, and yet Ninth Circuit judges are claiming in a Ninth Circuit ruling that Cox has a history of doing such actions. Seriously criminal, unconstitutional, and unethical actions. As if Cox has a pattern and history of illegal, unethical behavior of which there is no history or pattern. If these judges are allowed to put these unsubstantiated, unadjudicated, extremely biased, and prejudiced criminal allegations into a ruling in a civil case, then this will chill the speech of those in the future wishing to, wanting to, or trying to expose corruption in their area of expertise, their town, or their state. In truth, Petitioner Cox has dedicated her life, lost everything, and been under extreme threats, retaliation, and extreme prejudice for nearly a decade. All because she did the right thing and stood up for others, for strangers, and used her internet marketing skills to give voice to the victims of corrupt detectives, county commissioners, judges, cops, politicians, real estate companies, banks, finance companies, and victims of human trafficking, pedophilia, rape, and severe abuse. Cox was ruled guilty of a crime of which she was not even on trial for, was not adjudicated for, and was not under investigation for. A crime that was not a material factor in Obsidian Finance Group versus Crystal Cox. It is not legal, due process, nor constitutional for these judges to have stated these false, unadjudicated allegations. Petitioner respectfully requests that the Ninth Circuit Court amend its opinion to withhold the sentence that now says Cox apparently has a history of making similar allegations and seeking payoffs in exchange for retraction. See David Carr, When Truth Survives, New York Times, December 11th, 2011. A judicial assertion of misconduct by a named person, even a judicial assertion modified with the word apparently, could be based on the record in a case or an authoritative finding by another court. But it ought not be based on a newspaper column which was written without the benefit of cross-examination, sworn testimony, or other safeguards of the judicial process. The claims in the columnist's assertion are neither facts found by a fact finder nor facts subjected to judicial notice under Federal Rules of Evidence 201. Adding this statement to the Obsidian v. Cox ruling dated January 17, 2014 is legally flawed and has far-reaching consequences, and is thereby warranting review in this case. This issue affects all who are reporting the news, all citizen journalists, all victims of corruption at every level, and all whistleblowers. If a Ninth Circuit panel can rule that any individual has committed crimes without that person having been investigated or given due process for those allegations, and use a New York Times article as evidence of those crimes, then this potentially affects every citizen in the United States and is a very important issue for all lawmakers, citizens, and the judicial process as a whole. This court should grant this petition. Respectfully, Crystal Cox. So, there's where I stand on the issue of petitioning the Supreme Court for rehearing. I have made a firm stand for all citizen journalists, investigative bloggers, anti-corruption bloggers, and whistleblowers. And so there you go. I'll let you know what happens next in the Supreme Court, Obsidian Finance Group versus Crystal Cox. Take care.